Good afternoon. We have two cases on our docket this afternoon. We will take them in the order that they are listed and take a brief recess in between them to reconstitute the panel. The first case, number 23-1932, Abraham Omar McCray versus State of Florida. Appellant's counsel.
Thank you, Chief Judge Osterhaus. May it please the court, Mose Bracey, on behalf of Mr. McCray, I'd ask to reserve 4 minutes for rebuttal.
Noted. Thank you.
This case is about a trial judge not allowing a criminal defendant to present evidence in support of his theory of defense.
Let me ask you a question about
Yes,
that.
sir.
I'm sorry to cut to the chase for you, but and I appreciate the thorough brief you wrote. But why didn't defense counsel try to present any kind of medical expert testimony about whether those bruises could have been inflicted earlier?
Yes, sir. Well, Judge Thomas, I can't speculate as to why they didn't.
But isn't that a problem for your argument?
I really don't think so, sir. Okay. I really don't. And I say that because I think the question here really is where the bruises, where this, if we could call it, the evidence of the prior violent struggle, where that's concerned, I would say that, the issue is whether it's relevant, which I think in this case comes down to, does it tend to establish a reasonable doubt as to his guilt? And I think that even without medical testimony, a jury could have reasonably inferred that since that incident happened a few days prior, that those bruises could have, that struggle could have caused the respective injuries. So I think it would have been great if there would have been testimony. Of course, I'm not exactly sure if it would have been allowed, but I don't think that would be necessary.
And who was going to testify as to the prior incident?
ARB herself, the victim, yes, sir. And so if I could, it may help a little bit on this point to focus specifically on her testimony, the testimony that described the nature of the struggle, as well as the testimony that described the nature of the injuries. And so here I'm looking at 133 through 37 of the trial. And here, in terms of the nature of the prior struggle, ARB testified that a few days prior to the incident at issue, there was a violent struggle in a bathroom. ARB was basically lured into a bathroom, and then somebody tried to take advantage of her, and she basically got into a violent fight with them. During the fight, she was pushed into a wall, she hit the wall, and then she got into this violent struggle from the wall to the sink where she was forcibly pushed against the sink and fought a grown man. And she went on to clarify that she was pushed forward over the sink by the man. So that's the basic evidence we have of the struggle itself in terms of the injuries. And here I'm looking at pages 68, 90, and 105 of the trial.
And I'm sure we'll hear from the state regarding their view, but why did the state argue to exclude this evidence? They argued it was not relevant, but I'm just curious, typically in a criminal trial, this would likely come in.
And I'm sorry, Judge Thomas, you said, why did the state argue to exclude
Yes.
this? Well, my understanding, the way this initially came up was prior to trial, the state filed a motion in limine, and they had the hearing prior to trial. The defense basically at that point just represented what they believed the testimony would be. The state didn't want to have a proffer at that point from ARB. The state didn't object to the representation. The defense then ended by arguing this is relevant to our defense. The state basically argued it wasn't relevant. And then during the actual trial, the defense during cross-examination of ARB again tried to get in, tried to introduce that information. There was an objection, and at sidebar, as I recall, it wasn't allowed.
But the state's whole argument seemed to me to be based on the idea, unless I'm misreading this, that because there was no medical testimony regarding the nature of those bruises, it was not relevant. I mean, had there been some testimony that if your client had presented or proffered some testimony that, look, we have a medical expert, he's going to testify that the bruises that were observed on her during the sexual assault kit examination could have been inflicted 2 days earlier.
Yes, sir. Because
that was lacking, as I recall, the state argued it's not relevant. There's no evidence to show that, and of course she testified that, well, the prior incident only involved the upper half of my body. But I'm trying to get a handle here on exactly why this would be excluded.
Yes, sir. Well, Judge, of course, I'm arguing it should not have been
I know
excluded.
you're arguing to the
Yes, sir.
contrary.
What I would say is that the state's argument, which I believe you're more or less accurately describing, and I believe that also more or less describes the court's reasoning as best I could tell. I mean, basically the court seemed to agree with the state. I think fundamentally what that argument and reasoning gets wrong is the bar is exceedingly low for testimony to be relevant. I mean, the case law says things like contrary testimony goes to weight, not the admissibility, that it's not the key.
Well, I know you have two primary arguments here, the other regarding the knowledge that she found out about the rumor about the recordings. But on this one part of the case, tell us why it's not harmless.
It's not harmless, yes, sir. Just focusing on issue one exclusively?
Yes.
Yes, okay. Because I will say, Judge, I mean, I do think they can be considered cumulatively.
Of course.
But with respect to this argument, and I will say the argument I'm about to make also would apply individually to count two as well as cumulatively, I think the basic 2 points I'd want to make is that the permissible evidence, meaning the evidence that was allowed in, was not clearly conclusive. At the same time, the excluded evidence, the prior violent struggle, ARB learning of the rumor, it would have had an impact. And I say that.
It's interesting because in the federal courts, the standard is actually different.
I'm sorry, in the
federal courts,
yes,
the
sir.
standard is actually, shall we say, more lenient towards the prosecution.
Yes, sir.
So, but in state court under DeGuilio, it's a tougher standard for the state to meet.
Yes,
But you had her testimony, you had what else against you?
Well, really the two main things, Judge, were the presence of the injuries and ARB's testimony that basically she was drugged, passed out, and couldn't remember, much less have, consented to the sexual encounter.
And it seems like the injuries were a pretty big deal, and that this would have been a he said, she said oriented case, but you have all this bruising, that all the evidence was that this bruising came from, as a result of the crime here.
Yes, sir.
And the potential bruising from being, I think it said violently attacked and thrown around the room from a few days earlier,
Right.
was potentially kept out. I guess the part of that doesn't connect for me is that there was bruising to the cervix. Now, I get the physical bruises to torso, arms, maybe thighs. Inner thighs, I'm not sure I get, but why would your argument apply with respect to inner thighs and cervix?
Yes, sir. Well, just a few different points, if I could, related to the bruise on the cervix. One, I don't think, even if the bruise to the cervix could not have realistically come from the prior violent struggle, I don't think that alone would render evidence of the prior violent struggle irrelevant because, of course, there are other injuries that ARB says testifies happened during the encounter. I really think, and of course the bruise to the cervix would really have nothing to do with the evidence about ARB learning of the rumor, I don't believe. I think where the bruise to the cervix would really come in would be in the harmless error analysis. My position would be that even if the bruise to the cervix could not have reasonably been caused by the prior violent struggle, the errors still would have been harmless. I'm sorry, the state would still not be able to prove that the errors were harmless. And I say that, again, thinking about kind of the permissible evidence and the impermissible evidence or the excluded evidence. In terms of the permissible evidence, that bruise to the cervix, the evidence certainly did not exclude the reasonable possibility that that bruise was from something other than non-consensual sex between Mr. McRae and ARB. And I say that particularly because of what the sexual assault nurse testified to. One, she said, I can't tell you exactly what caused this. She said it could have been intercourse. She certainly didn't say it had to have been intercourse, much less it had to have been non-consensual intercourse. She also said that even though it could have been caused by friction or touching, it also could have been caused by, she used some somewhat technical terms, but I think she said a coagulation disorder, hemorrhaging, or bleeding. So she said.
But now he told the law enforcement that they had consensual sex.
He absolutely did, Judge Thomas. And I want to be clear, the verdict here certainly did not turn on whether they had sex.
I
It turned on.
understand that, but so he said we had consensual sex. He provided some rather lurid details,
Yes.
and then she testifies, no, there was no consensual sex. I woke up, I had these bruises, and people told me something happened, and how is that likely not harmless?
Okay, well, because in essence, the permissible evidence, it came down to her credibility and the presence of the injuries. I mean, there were no independent witnesses. There were obviously no recordings. Mr. McCrae, by way of his statements to Detective Allen, said, it was consensual, which again, that's what the whole verdict turned on. So I would argue that even amongst the permissible evidence, there's some reason to question ARB's testimony.
Well, so let's play that out then.
Yes, sir.
Let's say that the jury hears the excluded testimony.
Yes, sir.
Maybe all of it. Let's just say, obviously, that's what you have to do with a harmless error analysis. So the jury hears she had an incident where she was assaulted, physically assaulted, a couple days prior, and that afterwards she heard about this rumor that purportedly she had engaged in group sexual activities and it was recorded. That's it. So that's it, right?
Yes, sir, essentially.
Right.
Yes, sir.
So the jury hears that. She testifies. She was going to testify regarding the prior incident. That didn't cause these bruises. In fact, didn't she testify, if I'm not mistaken, that I didn't have any bruises before I woke up?
She did.
So
Yes,
the
sir.
jury heard that.
Right.
So you cross-examine, your defense counsel cross-examines her and says, well, wait a minute, you had this prior incident and you were physically assaulted. Didn't that cause any bruising? Well, she's going to testify, as she did, no.
But she's also going to describe the prior violent struggle. So,
Correct.
so the jury, so I think largely what I hear you getting at, Judge Thomas, is it came down to her credibility. And
I know, but logically, I'm trying to decide how the jury hearing about the prior incident and her testifying, as we know she would have for a fact, that no, that didn't cause any bruising. The bruises appeared after I woke up, or the handprint, et cetera. So the jury's going to decide, oh, we think you're lying and that you were bruised from the prior incident, and that I guess your whole theory would have been then, look, she found out about the rumor. She denies having bruises from the prior incident, but you, the jury, can decide whether that's credible. She testifies that she never consented to the sexual activity. He doesn't testify, as I recall.
no, sir, but his statements that it
I
was
understand
consensual.
that.
Yes, sir.
So his inculpatory, or what I guess you would call them exculpatory statements come in.
Right.
That, oh, we had sex and it was consensual. You think the jury would have returned a not guilty verdict on that?
Well, I think there's a very good chance, but I would also point out, Judge, and I know this is kind of splitting hairs, of course, the question is not whether they were returned, but whether, what I would say is this. I think that if the excluded evidence would have come in, the jury would have had to consider it. It would have weighed on them. It would have at least given them some pause. Maybe it would have just had a holdout. Maybe it would, because the point is here.
Well, D'Aquilio says would it have affected the verdict, which I'm not sure is, well, it's not the standards used in federal court.
Yes, sir.
But it's interesting. This is an interesting harmless error case because what does that mean, affect the verdict? In other words, you might have had a lesser of battery? Was there a lesser included? I doubt it.
I
I
can't
don't
say for
recall.
sure, Judge. I'm sorry, but I
But,
think there may have been. I'm not sure.
Right. Let's just assume there was a
Yes,
lesser
sir.
included of battery.
Yes, sir.
And so, i.e. affected the verdict means they might have come in with a lesser?
I think so.
Or they might have not been able to reach a verdict. That's
I
what
think
you're
that's
saying?
right. Yes, sir. I mean, it's a very, very high standard. The state has to prove beyond a reasonable doubt, and the Florida Supreme Court case law is clear. I think this is Knowles versus State. It doesn't have to substantially affect the verdict. It just has to affect the verdict. And so, of course, it's hard for me to basically prove a negative. I feel like is what I'd like to be able
So
to
in
do.
the federal court, you just look at whether or not there was overwhelming evidence of guilt, i.e. prejudice. In fact, I think, if I'm not mistaken, it's the same standard as prejudice from ineffective assistance counsel type analyses, right?
Yes, sir.
i.e., is there overwhelming evidence, so there's no prejudice? But that's not the standard in state court.
Yes,
I
sir.
acknowledge that.
And I wouldn't want to misspeak, Judge, but what I would say is if the court was considering,
I'm just curious, isn't that a more logical standard? I understand it's not, and I understand DeGuilio's been around for a few decades. But isn't that a more logical standard? Because aren't we being required to engage in some fairly serious speculation here?
Judge, I don't think so. I mean, I think either way there's going to be an element of, I don't want to say speculation, but an element of kind of gaming out how it could have gone, or even maybe how it went in the jury room. But I think that, certainly the Florida state courts have the prerogative, as I understand it, to enact the DeGuilio standard. And I would the one thing I would ask is if this court was considering just kind of addressing those concerns, that it would at least allow some supplemental briefing on that.
It's binding precedent.
Okay, yes, well, I just.
So you don't have to worry about that.
Well, I know it's binding, but if there was some discussion of that, Judge, I would be interested in contributing something that was a little more informed than what I have to offer today.
Well, harmless error is always on the table.
Yes, sir. No, I mean in terms of addressing concerns with the DeGuilio standard.
I don't think anybody's arguing for a certified question whether DeGuilio should be reconsidered, so.
Yes, sir.
You don't need to focus on that.
Yes, sir. Well, one thing I do want to say quickly on the harmless error, because I can tell that, there's some thoughts here about that. The excluded evidence would have had an impact, and I know we've touched on this a little bit, but evidence of the prior violent struggle, one, would have offered up a reasonable alternative in terms of what caused the injuries. Also, I want to be clear that it would have offered up a reason to question ARB's credibility, which again was critical because she not only said the bruises weren't there, or the bruises happened during this encounter with Mr. McRae. She said, quote, there couldn't have been another incident where she received the bruising, end quote. And of course, if this prior violent struggle happened just a few days prior, that would have impeached her testimony on that point. And then on ARB learning of the rumor, again, that would have directly undermined her credibility because it would have offered reason to believe that out of embarrassment, shame that perhaps people knew that she had even consensual sex with Mr. McRae and almost a threesome with his brother, that could have given her a motive to falsely claim, I passed out, I was drugged, I don't remember. And so again, that would have undermined the most crucial piece of the state's evidence, which was basically ARB's testimony. So unless there are further questions, I'd reserve the balance of my time for rebuttal.
Thank you, Mr. Breeze.
May it please the court, Julian Markham. If I could, just starting with issue one, I would like to address the timing in her testimony with respect to the amount of time that lapsed between the initial incident and the incident at issue here today. She was asked during her proffer by defense counsel if the earlier attempt to commit sexual assault had occurred within 2 days of the sexual battery, and she said no, it was not 2 days, it was within a week, but not 2 days. The phrase within a week usually connotes a period of time longer than a few days. Obviously, it wasn't in excess of a week, but
So is your point there that if it was 3 days prior that the bruises would have been gone? And
not that
if the first attack would have happened and it would have resulted in bruising, then the bruises would have been gone?
it's the further out that the initial incident occurred from the instant one, the more likely that it would have been.
But that all goes to the weight, right?
Well, it also.
Not admissibility. I mean, the testimony wasn't, the ruling wasn't based on the idea that it was so attenuated. The ruling was it was not relevant.
Right.
So, whether the jury, the fact finder would make those kind of determinations. In other words, your argument, the state's argument, the prosecution's argument would be, look, it was a week ago, there's no way. But the jury would have been able to hear that and decide, okay, well, these bruises were not inflicted by that prior incident. So let me ask it, maybe ask it a different way.
Okay.
Do you think that the prior incident was irrelevant?
I think based on the information elicited during the proffer, the relevancy wasn't established.
I'm sorry?
I think based on what was established during the proffer, the relevancy of the earlier incident wasn't established.
Why not?
Why not?
Why not?
Because I don't think that defense counsel was successful in establishing a connection between any of the injuries she described finding on her body on awaking in the tent of the appellant's brother after her period of unconsciousness were linked by that testimony to...
But I mean, the evidence, and I'm just asking
Sure,
in terms of
I understand.
clarifying the issue, but as I recall, the nurse testified that I could not tell you when those bruises were inflicted. Or there was some testimony to that effect, as I recall.
She testified that she could not tell after the fact when they were inflicted. The victim testified during her proffer testimony that she never had the bruises.
Now, I understand that, we know that, but the nurse testified that I can't tell you when those bruises occurred.
Right. But the only evidence we have of the bruising to this victim was her testimony.
Well, that kind of makes it more credible, right? I mean, her own testimony was that she'd been the victim of a prior physical assault.
Right, but that she hadn't sustained any of the injuries she described, in particular to her lower body.
Let's talk about harmless error. Just, at least for my purposes, assume
Okay.
that, just for the sake of argument, that we decide that the exclusion was incorrect.
Okay.
Why would you suggest it's harmless?
Well, because even if evidence of the prior incident came in, it doesn't explain, as proffered, as her testimony was proffered, the injuries to her inner thighs, and in particular, the bruising to her cervix, which was so unusual that out of over 70 examinations by this particular SANE nurse, she only photographed this one and 2 others.
But the
And-
nurse also said that that could happen in the course of consensual sex, correct?
Did she say that? I don't remember her saying, I suppose it's possible, but she said it was very unusual for those, for that bruising to appear.
That's what I recall, but go ahead, go on.
Okay. So you have that bruising, and the argument by the state, and I think it's common sense, is that injuries of that nature occur when the victim is not prepared for a sexual act. And you also have the appellant who admits to having sexual relations with the victim. And I just don't see how this evidence of this earlier incident, at which everyone agrees was not consummated, would have produced these injuries. There's no
But I mean,
testimony.
doesn't that sound like a closing argument? I mean, so it doesn't, I mean, it seems to me that, in a sense, we're hearing you make a closing argument to the jury that, look, had this evidence been admitted, ladies and gentlemen of the jury, you must use your common sense. There's this injury to the cervix that could not have been inflicted in the prior incident. Whether or not you think she might have had some bruising from the prior incident, it doesn't destroy her credibility regarding the other bruising that occurred here, which she denies. And then on top of that, ladies and gentlemen of the jury, the fact that she heard about this rumor and there had been recorded group sex, she denies that she had consensual sex. He claims that she did. You use your judgment, and, I mean, isn't that what the harmless error standard is kind of about, which is, if it could have affected the verdict, then it can't be ruled harmless?
Well, I'm just not sure how what was proffered could have affected the verdict, because there was just nothing proffered to
Well, there
explain.
was proffered that she was thrown against a wall, thrown against a sink. I mean,
Right.
a pretty violent encounter within the park.
It was a violent encounter, but what she described in the encounter, I can read to you what she described. She
Do you
was
think that that prior encounter couldn't have resulted in bruises on her torso and on her arms?
She testified, well, the injuries she described finding on herself were bruises to her inner thighs. I think it's just not established how being pushed into a sink could have caused an injury to the inner thighs. It just doesn't make sense. There was no testimony with regard to her initial, the assailant at the initial incident, grabbing her inner thighs. In fact, I think she specifically.
But I mean, there were injuries to her upper torso, right?
Right, but the only injuries that that came before the jury were a cut to the chest and a grab mark on the arm.
Well, that certainly could have been caused by the prior incident.
Yes, it could have, but they never elicited during the proffer that she was grabbed on the arm or that she,
I thought that's what she said. She was grabbed and thrown into the wall.
But not on
And
the
then she was
arm.
thrown into the sink.
but not specifically on the arm. There's just no connection that's been established. And as the proponent of the evidence, the appellant should have elicited that during the proffer.
What about the recording? What's your harmless error argument there? Assuming it's error, I'm not asking you to concede that.
Okay, thank you. The defense theory was that the rumor motivated the victim to fabricate this whole incident, or her account of this whole incident. However, she testified that on waking inside of the tent, she found the bruising on her and immediately walked out and started investigating what happened to her because she did not know. She wanted to clear this up. And she started talking at that time to members in her dorm, other residents in her dorm, about what happened. And this process was ongoing during the time that she heard this. She started receiving text messages or phone calls that conveyed this rumor of her having sex with multiple other people.
Of course, it was just a rumor, right?
It was just a rumor. It was just a rumor. So the rumor was not relevant because the victim was already suspicious in investigating the incident before she even heard it. And it wasn't until her discussion with the counselors at the facility that she actually received this rumor from Fat Frank, and they actually started looking it up on their computers to see if they could find it on YouTube or on Facebook. Moreover, she never called the police, nor was any evidence presented to establish that she initiated contact with the shelter's staff. All of this was done on her behalf. And she's never changed she's never pointed the finger, in counsel's words, at the appellant. She's never said that she was sexually battered. She said she doesn't know what happened. There's just no evidence, in other words, that this rumor had any effect on her at all. So if there are no further questions, I'd ask that
Thank you, Mr. Merkel.
My hope is to touch on a few things related to harmless error, and if I have time, something briefly on the rumor. But in terms of the harmless error, I just want to start with a few things. You know, one, in terms of whether the injuries could have been caused by the prior violent struggle, I want to be clear that, you know, ARB said he was trying to take advantage of her and he bent her over the bathroom sink. And I think it's certainly reasonable to infer that when that's happening, somebody can grab inner thighs and push them on, you know, push the person over by their back. So I think all of these injuries, other than the bruise to the cervix.
What about the timing on the rumor?
Okay, yes, sir. Well, Judge, here's what I would say there. I think that the timing was actually clear that she learned of the rumor before she started telling people, you know, I was drugged, I passed out, and I received the injuries in this encounter. And I say
State
that,
asserts to the contrary.
sir.
Your learned opponent asserts to the contrary.
And
Yes,
the
sir.
record seems to indicate that she said that immediately to him in the tent, which elicited him to have a sympathetic response and to gather her glasses for her and what have you. And she attributed that right in the tent in her testimony to the fact that she had told him that she couldn't remember anything.
Well, of course, a couple of things there. I mean, that is according to ARB's testimony that she told Mr. McRae that. You know, and again, it's her credibility that's the concern. I mean, under the defense theory, she was not, you know, she was not telling the truth when she testified.
I understand that, but what does the testimony show regarding when she heard about this
Yes, sir.
rumor?
Yes, sir. Well, on pages 100 through 101 of the trial transcript, she says she woke up and was trying to piece things together. She didn't know what happened to her. She talked to people to try to figure out what happened to her. And at that point, she started being called by people who said things she found extremely offensive. At that point, the state's hearsay and I believe also content objection was sustained. And so I think that when you look at that, and I would also note that on page 97 of the trial transcript, the defense represented without state objection that at the time of hearing of the rumor, she says she doesn't know anything that happened. Then she says, I'm a victim. She's telling the officers something must have happened to her. And so I think that, you know, if she's trying to figure out what happened to her, she's not at that point in time saying, I was drugged, passed out, and received these injuries. But here's the thing. Even if there's some lack of clarity of exactly what the timing was, that goes to the weight, not admissibility. Furthermore, I don't even know even if we knew that the timing was rumor first, I passed out and was drugged later, I still think it would be relevant because the question is, was she credible the day she testified? And, you know, she still could have changed her testimony over time. Now, the state may have been able to introduce a prior consistent statement, but that's a whole other issue. So if I could just very quickly touch on...
Briefly sum up.
Yes, sir. Yes, sir. Well, one, I would just say the harmless error is a very, very high standard. It's a very high standard. And to close, you know, in Vanier versus State, V-A-N-N-I-E-R, the 4th District basically stated, where evidence arguably tends to show a fact that may lead a jury to exonerate a defendant, the trial judge's discretion is reduced. And here, the excluded evidence, you know, it tended to show certain facts that might have led a jury to finding him not guilty. So the trial judge abused its discretion. We'd ask this court to reverse and remand for a new trial. Thank you.
Thank you, counsel. We'll take a brief recess.